So, okay, I'm going to pilot the PowerPoint presentation that I did. It is posted to Brightspace, sort of just giving you an overview of the Quebec Court of Appeal decision that just came out on Thursday on the C92 reference. It's big. It's also, yeah, I'm still not 100, I think I'm 90% sure about how I feel about it, but there's still parts that I'm trying to sort of figure out. But it is big, that's for sure. So yeah, let me walk you through it. This is more for your edification. You're not going to be tested on C92, at least on the sort of new decision. But it is just, so you to be aware of it, right? This is a really current issue. Chances are it's probably going to go to the Supreme Court of Canada. So, so yeah, here's my PowerPoint. I'll try to probably try to cut this off by probably 20 after, 25 after. But that'll give us still enough time to do the other stuff. But figured I'd review it. A few of you have said you're super interested in hearing about it. So yeah, trying to give you some of the highlights of it. Also, some initial thoughts I've had and also critiques I've heard from some of my academic colleagues. So, or yeah, thoughts and critiques. Okay, so it came out Thursday. And so whenever I get a judgment, well, it's kind of like when you get grades in law school, but probably magnified. You'll have this in practice. I don't know, you've gotten decisions, right? When you get a decision and it's sitting in your inbox and like your heart is kind of like up here in your throat. Anyway, the first thing I always do is go immediately to the bottom of the decision to figure out the results, right? Which, I don't know, maybe you should read the whole thing. But so the immediate result that the court had is that the act is constitutional, except for section 21 and 22.3, which are not. Those two provisions, section 21 said that that was in the section about Indigenous laws in Bill C92. And it said that all Indigenous laws that went through the process set out to have collaboration agreements would be given force of federal law. And 22.3 said that those Indigenous laws would be paramount over provincial laws. I mean, with section 21, that would have been the effect anyway, because the effect of making it a federal law, constitutional law, is to make the Indigenous law paramount. So they're related, these two concepts. And yeah, so they've said, and we'll unpack it a bit more, that these two provisions are unconstitutional. But they have another sort of alternative to paramountcy, which I'll talk to you guys about. But some of the people who've been working with this act and trying to work with communities and developing their own law, some of the immediate questions were like, does this gut the act? Is, because, that was a big part of what made this sort of a cool thing, is that it was, these were paramount over provincial child welfare laws. So this is the sort of question. Anyway, the court does get into it in quite a bit of depth, so I'll take a look at it with you. And then there's one academic who's quoted as saying, this is a slam dunk for the Indian Act. And I don't know if I agree with that. Well, you can judge for yourself once I sort of walk you through the sort of main points. It's massive. It's 207 pages long, single space, so 571 paragraphs. So in terms of like the legal effect of it, technically references are not binding, but as a matter of practicality, they are often viewed as such, right? Secession reference is is technically an opinion and not a binding decision, but practically speaking, they have that effect. They're viewed as decisions. Now, another provincial appellate court could take a potentially different view of the legislation. Just think about the greenhouse gas case. There was a bunch of different decisions from different courts. There is no other similar reference going on in any other jurisdiction. What's likely going to happen is it's going to be appealed. So under Section 36 of the Supreme Court of Canada Act, leave to appeal is not required. So there's just an automatic right to appeal. And they have 30 days. So Quebec could appeal and Canada could potentially cross appeal. Yeah, so mid-March is when that would be due. Okay, so walk you through just a few parts of it, all the parts of it, but just to give you a few highlights. So there's a massive section over 100 paragraphs long, which is just the context of the case. And they go into detail around the Indian Act, pre-Confederation, residential schools, emphasizing the assimilative and colonial nature of all of these things. It's quite remarkable, the depth to which they review this stuff. And they talk about, the sort of modern incarnation of the child welfare system sort of becoming the residential school system effectively. And they talk about the underfunding of the First Nations Child and Family Services Program. So lots of emphasis on that as part of the context. And then they also spend a massive amount of time talking about a bunch of different reports. So remember us in Module 2 talking about what's the relevance of these reports. Well, the court went hard on these reports and kept coming back to them throughout the decision as grounding a lot of their findings and their decision. Especially the link between control and self-government being exercised by Indigenous peoples as a remedy to colonial assimilative impacts of federal and provincial colonial policies. So that's really something too. I found that remarkable. They also emphasize the chronic underfunding and jurisdictional disputes as a major part of the problem. And so I was on for Caring Society. This was a major part of what we tried to emphasize in our submissions, and clearly it resonated. They also mentioned the Canadian Human Rights Tribunal Caring Society decision. They talk about the government's fiduciary duty to Indigenous children and families, substantive equality, and Jordan's Principle as all relevant. So that was, that's pretty out as, and it's long. I was just like, wow, they talk about this a lot, more than just a little paragraph that mentions it, but goes into it in a great degree of depth. So they set that stage at length, and then what do? Then they have a whole section where they go into the Act, and those of you who might be dealing with the Act or working with the Act might want to go consult these sections. They give a detailed analysis of the various parts of the Act, including quite helpful interpretations of the minimum standards that are developed in the Act. So those of you working with it might want to check those out. I think there's some good stuff to work with there for people who are trying to argue for a broad approach to the Act. They also place the legislation in line with a bunch of other federal initiatives, like the Department of Indigenous Services Act. There was this act that was passed around the same time as C92 that tries to put more sort of accountability around what the Department of Indigenous Services is supposed to do in the delivery of services to Indigenous folks. They also say it's in line with the UN Declaration Act, and I'll talk about how they use UNDRIP more in a bit. And they also say it's in line with those 10 principles. So we looked at those in Module 2, right? So they bring that in as well, saying that these are all in line with government initiatives. And they say about C92 that it doesn't just affirm self-government over child welfare. It seems to establish Aboriginal self-government as a general and generic right. And that's what they conclude about the right to self-government too a little later, which is exciting and kind of goes counter to what the government parties were trying to tell them not to do. So I'll say that in a sec. They also spend some paragraphs looking at critiques of Bill C92. They say it's not perfect. They say it's not a panacea, and they raise some of the problems about it, including the fact that it's fairly unclear around funding obligations. So they bring that up. Anyway, and that's all they say. They just mention that these are ongoing issues with C92, but they say that's not for us to decide today. But they wanted to mention it. And yeah, part 3, they review the different parties' submissions. And both Quebec and Canada didn't want them to weigh in on whether there was a right to self-government over child welfare. They just said, you can decide the constitutional questions without really getting into this. And Canada even made this argument, and I think I mentioned it before, that they said it was recognizing sort of a generic right, but then people would have to prove it on a case-by-case basis potentially afterwards. But the court says all those things that they tell them to say, but we'll see that they kind of conclude the opposite. They actually get right into whether there is a inherent right to self-government. So let's start with Section 9124 and the jurisdiction of it. they adopt a pretty broad approach of what 9124 is, primarily by looking at the past case law and essentially concluding that Canada has occupied the field by legislating in virtually every sphere of Aboriginal rights. And the courts have recognized that. So they say, yeah, it's already kind of recognized that it's this broad. And they find that in pith and substance, it's about protecting and ensuring the well-being of Aboriginal children and families by promoting culturally appropriate child welfare services with a view to ending overrepresentation. And they also find that recognizing the inherent right to self-government is in line with that. So they say it is in pith and substance in relation to 9124, and this is an area of double aspect as well. So there are some impacts on the provinces, but nonetheless, the effects on Quebec are fairly minimal. And yeah, so they look at what Quebec was arguing would have been impacts on its jurisdiction, and they say, man, it's pretty minimal, Quebec. They make one little comment that, you know, to be really sort of encroaching on the provinces, they give the example that a law that might encroach too much is federal legislation establishing thresholds for Indigenous representation in the provincial public service. So that would be a lot. That would be like, you know, right in provincial jurisdiction. So still a relatively broad approach to 9124. One of my colleagues, this is what's in red on the slide here, suggested that, or said, you know, in giving this 9124, they mostly just look at the case law. They don't go back to like the treaty relationship and the Royal Proclamation to kind of say what, there's no reflection on what this sort of earlier historic relationship, how it might limit 9124. And I think that's a fair criticism, but nonetheless, still a broad approach. And we'll see too that they quite endorse governments using 9124 in legislative jurisdiction to protect the rights of Indigenous peoples. So, all right, so that's that. And the next part of the decision, the really big part, it's a couple of hundred paragraphs long, is talking about the constitutionality of the Act vis-a-vis Section 35. So, you know, first, you know, Quebec was trying to argue that Canada was like recognizing self-government for the first time, and they didn't buy that. They said, look, it's not a new political or legal concept. It has been percolating for some decades, albeit timidly, and has found some place in the federal legislative environment. So they look at a bunch of different places where the feds have recognized self-government to some extent. Okay, so old tool lovers, they go back to the Royal Proclamation, they go back to the earlier treaties, they look at the Marshall Trilogy explicitly, and they say inherent rights, the inherent right to self-government has historical foundations and was recognized at common law and has become part of Canada's constitutional architecture and is protected by Section 35. So that's pretty big. We've not had a court do that yet, right? So my colleague, Kent McNeil, I sent the judgment to him. His first reaction was probably the strongest affirmation of the inherent right to self-government yet in a court decision. On the other hand, you know, they don't do everything. Nothing is ever perfect. What they say is they adopt this test from Mitchell, and I think it was discussed in Module 3 in the Kent McNeil article about the inherent right to self-government. Effectively, it's very much in line with Kent's proposal for the sort of full box approach. And basically what it is that it assumes that Aboriginal inherent jurisdiction exists and was incorporated into common law unless the feds or unless the governments can show that either that exercise is inconsistent with Crown sovereignty, was voluntarily ceded by treaty, or the government has extinguished the right. And we're going to talk about extinguishment in some future classes and probe that a little bit more. Yeah, so in that regard, they generally find that Indigenous self-government is not inconsistent with the division of powers or the constitutional architecture. And in that regard, they agree with the Campbell decision that we talked about in Module 3. And they say there was clearly no clear and plain intent to extinguish the right to self-government in relation to child and family services. So these are also big findings as well. Now, one thing we could criticize it for is that it doesn't question the doctrine of discovery, right? it more adopts the sort of US style kind of doctrine of discovery light. It's there, but it still allows a heck of a lot of Indigenous jurisdiction, which is, something we can critique in its own right, for sure, but definitely a step beyond where we have been in Canada. So yeah, that's sort of a big finding. Okay, to unpack a little bit more, so they go on to say that nothing stops Canada or Parliament. So this has been argued too, that because the courts had not found a right to self-government yet, this prevented the federal government from passing legislation. And they have a whole long sort of passage where they're like, no, of course the government can legislate. Yes, we might review it as the courts, but we are, yes, we are guardians of the Constitution, but governments should and do have an obligation to legislate. So they talk about that role of the government in implementing Section 35, which I want to go back to and look at more because I find that super interesting. So they say a lot about that. And then they turn to self-government over child and family services specifically. And they talk first about the purpose of Section 35. So there's some cool stuff going on here, primarily, and we'll talk about the sort of what the courts have said about the purpose of Section 35. They primarily focus in on what the court said in Sapir and Polcheese and Gray, which you looked at in con law. But they say the purpose of Section 35 is to ensure cultural security and the continuity of Aboriginal societies concerned, as well as to protect Indigenous people so they can express themselves and flourish as peoples. So they put an emphasis on this idea of Indigenous peoples flourishing as peoples and talk multiple points about Indigenous folks being collectives and organized societies. So they put a lot of emphasis on reconciliation being about recognizing that as well, which I think is sort of new and to some extent. Okay, the next neat thing they kind of do is they say that self-government over child welfare is a generic right. And that's based on the writings of a guy named Brian Slattery, and I'll include some of his stuff when we get to this Aboriginal rights module. But he has this whole theory looking at the various cases that some rights that the courts have developed under Section 35 require specific proof. But then there's some, like he says, like title, are a generic right. They're a right that all Indigenous people ought to have. And the court agrees with him about self-government, specifically with respect to self-government over child and family services. But you can kind of get that they're talking about all of it. And so, yeah, they say it's a generic right. And so it's enjoyed by all Aboriginal people, and it doesn't require any further proof, which is super interesting. So no Vanderpeet or Pamajuan test. It's a right to self-government. That's that. And in coming to those conclusions, the court doesn't apply the UN Declaration through the presumption of conformity. Yeah, they say, like the charter, a bunch of international law informs the charter. They say that, same thing for Section 35. The UN Declaration informs the interpretation of Section 35. So I got the paragraph numbers there if you want to look at it. So I think that is pretty cool. I think it means that the Indigenous groups do not now have to prove a right to self-govern over child and family services at the least. I think you could push that further as well. Yeah, because it's now regarded as a generic right. And we'll unpack the generic right idea a bit more in the future cases. So last part of what I'll talk about what these guys say is, so this is where they get to sort of why they think Section 21 and 22 of the Act is invalid, borrowing from federal paramountcy rules. Essentially, they say the framework for dealing with conflicts between Indigenous laws passed under the inherent right to self-government is the Sparrow justification test, Section 35. That includes dealing with conflicts between laws. And you can go read the paragraph after. I know it's small font. But essentially, they seem to suggest that in the most cases, provincial laws will be paramount, or sorry, Indigenous laws will be paramount over provincial laws. That's their intent, but in the vast majority of cases. And they also suggest that it will be hard for provinces to meet the sparrow test. And so they set out in some paragraphs that if a province took the position that its laws should be paramount over Indigenous laws, and even on that, the court, sorry, I will read this little paragraph 497 up here. They say, when there is an actual conflict between Indigenous and federal or provincial laws, then the Aboriginal right must be found to have been infringed. Since the Aboriginal right is recognized and affirmed by Section 35, the Indigenous law must prevail. And they say, to conclude otherwise would render the section meaningless. And so it should prevail in cases of conflict unless the government meets a sparrow test. And they say that's going to be hard to meet. And they go on at some length to say if a province wants to suggest that its laws should prevail, they will have had to have consulted and accommodated. They have to prove that they have a compelling and real public objective, that it's consistent with the honor of the Crown. They also have to meet their fiduciary duty to show that the infringement is proportionate, and it has to be strictly necessary to achieve the objective. So sort of like an Oakes test, we've seen this before, and we'll talk about sparrow a little bit more later. So that is the approach that they take. This is, I think, my second to last slide. I'll skip that first one, but essentially they think that this is the better approach over the paramountcy approach that they have struck. And they also say that they think that the paramountcy approach that the federal government was trying to put in the law goes too far. It takes too much power away from the provinces. And they say, first of all, that's not in keeping with Chilcotin and Grassy Narrows, where the court said that Section 35 is the framework for both the federal and provincial governments to deal with Indigenous rights. And they said Parliament cannot narrow or broaden the scope of Section 35 by taking away the province's ability to make an argument based on sparrow. And doing so without the agreement of the province alters the constitutional architecture. So their view is that 35 ought to be the vehicle, not Section 91-24. So this is the part where people are trying to figure out how they feel about it. There's some people who really don't like this. Those who really hate Chilcotin and Grassy Narrows. I haven't talked to John Burrows yet about his feelings about it, but he probably has an issue. But some other people of the same sort of sentiment think that this ignores the historical Crown-Indigenous treaty relationship where the feds are supposed to protect Indigenous folks from the provinces. At the same time, Grassy Narrows and Chilcotin are the law, right? Like the Supreme Court decided those in 2013. So, and we do kind of have this situation of where we have both the federal and provincial governments at play. Those working in communities and who are working with communities to pass laws under C92, their concerns are more in practice that this is just going to make it harder, perhaps, because the provinces might try to argue that their laws are going to be paramount, whereas it was much easier when you just could point to those two sections in the statute and say, paramountcy, we got it, that's enough. But the worry is that we're going to have to now convince the provinces or teach them about how sparrow works and sell them like, you can't, in most cases, your law is not going to be paramount. It's going to be the Indigenous law, and that's what Section 35 requires. I had another colleague who said, well, it's kind of naive to think that all the provinces are just going to come to the table. So this is the real tension about whether we think this is a really, really good decision or not. The last thing I'll say on it, as I was trying to figure out how I felt about it, is there's a huge chunk of the decision, and I'm not going to read the paragraphs to you, but those are some of the paragraphs of it, where the court kind of explains its reasoning here about why it feels that Section 35 is a better framework than trying to use paramountcy, federal paramountcy. And they actually talk about it achieving a much needed paradigm shift in how all governments treat Indigenous peoples. especially as it relates to child and family services here. But they say, you know, up to now, there's been this whole confusion around the feds and the provinces. We've mostly left it to the federal government, and it's been a disaster. And they said, you know, moving forward, you know, what will really work is actually seeing both levels of government having obligations here. So some of the quotes, they talk about Jordan's principle, this idea that both the federal government and provinces ought to be on the hook. And they even mentioned funding and that government should have a role in funding. Yeah, so this point here about that it shouldn't, they sort of suggest that the federal law was somehow, they say we must avoid reinforcing the idea that Indigenous peoples are passive subjects that the federal and provincial governments can regulate within their respective jurisdictions. Like the Canadian Charter, Section 35 introduces a paradigm shift in the architecture of the Canadian Constitution. It thus decisively alters the relational dynamic between Indigenous people and the Crown by giving them a special status. Yeah, and then it goes on to talk about how we got to change the way things have been working, which is like fascinating, right? Like they have like a whole vision of how you know, things are supposed to change under Section 35. Is it naive? I don't know. But when I read this part of the decision, you know, I kind of get where they're coming from on how they ruled, but it kind of assumes that the feds and the provinces are going to kind of be willing to step up, which has been a real challenge. Anyway, that's it. That's it for this decision. I just wanted to tell you about it because it's huge and is probably going to the SCC in a little, it probably will be. I'm assuming that Quebec's going to appeal it because, you know, I think it goes way beyond what Quebec was expecting. Yeah. Any thoughts or questions about it?